Arkansas rental applications help to collect essential insights on potential renters. Going through this route helps to ensure that the best possible tenant is selected. The process may include a background check on criminal history, credit, eviction records, and much more. In this video, we've put together some information to help you understand what goes into the Arkansas rental application process. Welcome back, everyone. I'm Santiago with DoorLoop. Now, before we get started, let me remind you that I am not an attorney, so I cannot give you any legal advice or financial advice. And yes, I do work for DoorLoop. Okay, that being said, let's get right into it. Arkansas rental applications. Arkansas is home to two different types of applications. The form that a prospective tenant will use depends on the lease agreement to be used, as well as the property type and relevant statutes. General rental application form. Most tenants will use this rental application form. While there is a standard variation that an Arkansas landlord may wish to use, the process also supports customization, which allows for data collection that may be better suited to the unique needs of a property. Department of Housing and Urban Development rental property application. A landlord dealing with a low-income tenant or one offering Section 8 housing will use this document. It is customized to capture information that aligns with rules governing subsidized housing. Arkansas rental application form. Some of the examples of the allowed components of the rental application are personal information of every tenant that will live in the house, written consent for credit history checks, written consent for background checks, financial information such as income, personal references, and employment details. What not to include. There is some information that the Arkansas rental application process is not allowed to collect from potential tenants. These include familial status, disabilities, sex, religion, age, nationality, color, race. Drafting rental applications. In working to develop an Arkansas rental application, it's non-negotiable to ensure that the document is compliant with legal requirements before passing it to a possible tenant. A failure to do so can create costly consequences. That's why you should always keep the following in mind. Security deposit. Arkansas has two tiers of security deposit charges, depending on your ownership status. If a landlord is to collectively own 5 properties or less, there is no cap placed on security deposits. However, should a landlord cross the threshold of 5, then under the law 18-16-304 and 18-16-303, it becomes illegal to charge more than 2 months' rent for the security deposit. Background checks and credit check consent. According to the Federal Credit Reporting Act, before landlords can proceed to carry out a credit check on any applicant, consent must be given to do so. While it is possible for a tenant hopeful to provide the information separately, landlords will often provide an area on the rental application with a pre-written statement that speaks to consent being given for the credit history check. An applicant can simply provide a signature, which is enough to indicate permission being received. Eligibility notice. Should any screening criteria potentially affect the chances of an applicant, landlords must disclose information about it. The idea is to ensure that those who submit rental applications can pinpoint what may be the reason for acceptance or denial. The applicant must provide a signature of acknowledgement. This not only shows that the person read the points of information, but it is also a statement of acceptance. Housing discrimination protection. This is where the Fair Housing Act comes into the process. This is a federal-based piece of litigation that expressly prevents landlords from rejecting the application of anyone for discriminatory reasons. This policy goes back to the areas not allowed to be on the form, such as familial status, sex, race, disability status, etc. Technically speaking, criminal history discrimination is also not allowed. You must abide by the rule even if you discover a criminal record during the background check process. Application fee. There will usually be a non-refundable application fee, synonymous with the document used to start the application process. Federal law doesn't directly speak to what this figure should be. Additionally, there's no state law to provide direction. Therefore, landlords could theoretically make the fee whatever they may desire. Since the charge is meant to help cover the process of screening possible tenants, it's recommended to set a figure that is most conducive to the process. For example, your background checks to discover rental history or criminal history come at a cost you must bear. Eviction records. Rental history tends to be a big part of the process. A concerning pattern of eviction records, for example, is an indication that a tenant may be less than optimal. Thankfully, Arkansas evictions are public record, so you can use Court Connect to access them, or you can rely on a third-party business or piece of software. Adverse action notice. Though you cannot discriminate against applicants for highlighted reasons, you can take the adverse action notice route to either reject the application, require a higher rent, ask for a cosigner, or increase the deposit. The process would involve providing a notice document to prospective tenants with the details of the matter. Build your own. The good news is that you can access this in Microsoft Word or PDF formats, and we left a link right there in the description for you. Alternatively, if the predefined details are not extensive enough, you can actually build your own document instead. Okay, so the bottom line is, the application process to secure housing in Arkansas comes with several nuances and caveats. Property owners must bear the relevant policies in mind to remain compliant with the applicable statutes. Let's go over some frequently asked questions. What are some main reasons to draft an Arkansas rental application form? Setting up the document adequately allows for the following: gathering information on prospects. Screening applicants becomes a more informed procedure. Tailoring can be done to get nuanced details. Are there any situations that would allow exceptions to the Federal Fair Housing Act? Yes. For example, if there is age-restricted housing, an exemption can be made to allow age details to be requested. Is it difficult to get access to a potential tenant's eviction history in Arkansas? No. Eviction history is a public record and can be accessed directly on Court Connect or via the employment of a third-party software or company. And that is it for now. Now remember, if you want to get access to a lot more content, such as videos on real estate technology and artificial intelligence, or on commercial and residential lease agreements, make sure that you like this video, subscribe to our channel, and share this with your friends, your team, and basically anyone that you know in real estate. Okay? And as always, thanks for watching.